rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Please be seated. Good afternoon. Welcome to the First District Court of Appeal. We have 3 cases on the docket today. Between the first and second one, we invite counsel to have coffee with us in the rotunda. And Mr. Sicking, if you're ready, you may proceed.
Your Honors, may it please the Court. I am Richard Sicking from Coral Gables for the appellant, Anna Lee Ortiz, and with me today is Mark Toby, the co-counsel, also from Coral Gables. I'd like to save 3 minutes for rebuttal.
Mr. Sicking, would you pull the microphone a little closer to your mouth? Great, thank you.
The claimant suffered a compensable injury in 2003 that involved the surgical removal of her right kidney. 12 years later, she moved to Orlando, and at that time, the carrier authorized a urologist, a Dr. Young, to treat her then and for annual follow-ups. I repeat, for annual follow-ups, and more often as necessary, for 2 conditions, one of which was pyelonephritis and the other was a urinary tract infection. The trial judge found as fact that over the next 5 years, Dr. Young, the authorized treating physician, saw the claimant and treated her for these 2 conditions, sometimes one, sometimes the other, sometimes both. And this continued as authorized medical care, quite importantly, to February of 2020. This is now 5 years later,
Counsel,
when she had an MRI.
Counsel, when was the first payment made ever on the claim?
Well, the first visit was paid for, the record shows, and all the visits up until January of 2020 were paid for, yes.
No, I mean, what's the date after the accident? Is there anything in the record that shows any payments at all, or dates of payments?
This record contains nothing prior to her trip to Orlando for moving and the medical treatment that was authorized from that point forward.
Sure, okay. So is there anything in the record, even after she moved to Orlando, showing payments made, like dates of payments made by the carrier?
The adjuster indicated that they made payments, and the record does show payments through January of 2020, you see. And that seems to be the point of the statute of limitations in this case. But on the other hand, there's a very important issue about authorization, because the authorization actually fixes everything. In February, the doctor had her have a...
Counsel, the reason I'm asking about the dates of payments is it seems like the tolling all turns on dates of payments, like when it starts, when it stops. And there doesn't seem to be a lot of attention paid to establishing the record to get that chronology straight.
The record shows that the carrier paid for all of the visits for the 5 years from 2015 through January of 2020 under workers' compensation, no question about that at all. The record also shows that beginning that time as the subsequent visits in 2020, those were billed to the group insurance carrier, and the trial judge found as fact that there was no satisfactory explanation as to why that was changed, but that's what actually happened. That's the facts, and we have to deal with that. This is not the first time that's happened in a case, and we have rules of law to deal with it. The claimant was treated for the kidney infection of the other kidney and her urinary tract infection for 5 years following the first visit in 2015, all of which was authorized. In fact, the judge found that...
So what of Dr. Young billing the last 3 UTI visits to her regular health insurance instead of putting in comp?
Well, what happened was the doctor billed after January, except to group insurance, except that something happened. In the next month, February, she had an MRI, and then in April, he saw the patient again to go over the MRI, and the February and the April medical care was sent to the carrier in June. The adjuster said she got it in June, but she never did anything. She did nothing with it. But then in August, she filed a notice of denial. And the only notice of denial was that the statute of limitations ran because she said, we haven't paid for any medical since January of 2020.
Well, didn't
2019.
didn't she testify that the doctor, Dr. Young, said bill it to your policy, not to the workers' comp? I mean, I thought I read her testimony to say that, why'd you do it? Well, my doctor said I should do it, so therefore I went along with it.
That's not what the record says, nor what the judge found. The judge found that the changing from the comp billing to the group insurance billing was never satisfactorily explained. And in fact,
But I thought that was her testimony. I thought that's what I read.
well, it's simply that it happened. So it could have been for good reason, bad reason, no reason. It simply happened. But it doesn't legally change anything because the medical care was always authorized from 2015 until August of 2020.
So the 3 visits she had that we're here today about, the 3 visits she had, if her doctor had submitted those to the employer carrier, we wouldn't have a dispute, right?
That is certainly correct. But there is no one-year gap here of any kind between medical treatment that was authorized to start with and not controverted or denied until August of 2020, and the PFB was filed 3 weeks later. The issue seems to be, on that point at least, that the carrier didn't pay the bills, but they were still authorized medical care and obligated to do so whenever it's sent to them. This is true. That's not a problem. The real situation here is the trial judge found that there was no medical evidence that the treatment that they authorized was causally related to the industrial accident. He said that's the rule of law. He's wrong, because the rule of law is, and always has been, and is plainly set out in the Sanchez case and in the Cespedes case in the briefs, that when there is authorized medical care, the authorization relieves the employee of the burden of proving that the authorized medical care is causally related. That makes perfect legal sense. What happens from the cases is that the burden then shifts to the employer carrier to disprove causal relationship. The judge made a serious error in paragraph 24 when he said the medical evidence shows that the medical treatment was not related. That's imaginary. What was really happened in this case is there's no medical opinion evidence at all. There was no proof that it was. There was no proof that it wasn't. Not yes, not no. It just isn't there.
Well,
and
counsel,
so it's imaginary for the judge to find that the medical care which they authorized was not related. That's not, there's no evidence of that at all. And in fact, the law is from Cespedes and Sanchez, and has always been, authorized medical care, the employee has no burden to prove that such authorized medical care is related. That would make no sense at all. The burden shifts to the employer carrier to prove that it's not.
Right.
And they never did. They never presented anything that wasn't either. That's why you should be reversed.
Here's what I'm struggling with. I think there's actually 2 things going on. There's the merits of should the carrier or the employer have denied the authorization in the first place based on statute of limitations. I question whether an employer carrier can use the statute of limitations as a basis for denying authorization. But that's on the merits. Before you can get to the merits, you have to cross the threshold of can you file a petition for benefits in the first place to deal with this. And now you have to deal with the statute of limitations, which is an affirmative defense that the employer has asserted. And I guess I should ask, do you deny that your client bore the burden of establishing tolling? Do you acknowledge that, first of all?
First of all, it is always in the setting that was authorized medical care. Now, you're saying, well, all right, the doctor sent the bills to the group insurance carrier after January of 19.
No, you're jumping.
Right,
I'm not even
right.
talking about those
no.
3 bills. I'm just talking.
The earlier ones, there's no question. The adjuster said, I got the bills and we paid them. The record plainly shows the carrier paid for 4.5 years, and it's only the last part of 2020.
Right, but you still have a math problem that you have to address, it seems. So to file your petition, because the statute says there are no petitions for benefits that can be filed after 2 years. That's your statute of limitations. Then there's an exception. There's the tolling, and it runs, you get a 1-year tolling from the time of the payment. So now you have to calculate, okay, in my 2-year period, where's the tolling starting and stopping, and did it toll, and did you submit evidence
Yes.
in the record to establish the
In
tolling?
this case, yes, because the authorized treatment for the conditions which were related to the injury has no 1-year gap between the visits. It's all set out in the briefs, all the dates of the visits from the record. There is no 1-year gap. It's within a year. And remember, in the very beginning, the authorization was for annual follow-up visits, because this had been going on for 12 years before she moved to Orlando. So the question then is, well, is there any statute of limitations problem with the fact that the bill hadn't been sent to the carrier yet? And the answer is there are myriad cases, and they're all in the brief, that show that if the doctor doesn't bill at all, that's one of them. Another one is where he billed the claimant and the claimant paid. And another one where the doctor sent the bill to a third insurance company instead of the work comp carrier. But this court held, that all of the medical treatment was furnished because it was authorized, and the statute of limitations is told because the medical care was furnished, and they haven't denied the payment. It just hasn't been presented to them. And so consequently, the statute of limitations is not run when it was filed 3 weeks after they filed their denial. That's as promptly as you can get.
Yes or no? The statute says that the tolling runs from the date of the payment. Is that true or false?
Cases have always held that
The statute.
No.
What does the statute say?
Yeah, but here's the point. The front part of the statute says it runs from the furnishing of the treatment. In this particular case, the reason the bill hasn't been paid yet by them is because it hasn't been presented to them. If you follow that reason, all the carrier would have to do is simply not pay a bill. That's not the way the workers' compensation law works. It works with the furnishing. The bill hasn't been paid yet, as you point, because it hasn't been denied yet either.
But there was a payment before.
But the medical care was furnished by them because it was authorized. That's what the case is about, and that's where the judge was wrong and should be reversed.
Your Honors, may it please the Court, my name is Bill Rogner, and I represent Winn-Dixie Stores. Judge Tannenbaum, this case is about burdens of proof and lack of evidence. They chose not to, A, depose the doctor. The doctor could have explained whether these UTIs were causally related to the injury.
But isn't that pretty evident from the record? I mean, this woman lost a kidney. The kidney is connected to that whole system where these infections occur. She's been treated for both the kidney and for the infections over the years with the same physician,
Right.
with never a peep about it being unauthorized.
Exactly. But there's
So
no
why
evidence.
do they have to go through it? You're making it sound as if there's this really heavy burden of proof
No.
that a claimant has to make to get ongoing treatment.
Let's go back and look at the testimony, okay? The adjuster testified. She authorized this doctor. This doctor was authorized to treat the kidney, and she was to go there for her annual kidney follow-ups, and you'll see in those records that the doctor often did a kidney ultrasound, and the doctor often did CBC work to test for the kidney to see how it's functioning. The doctor also treated her for UTIs. And the adjuster testified at page 95 of the record. The UTIs were never accepted as a compensable condition. There is no evidence we provided treatment for the UTIs. The treatment for a UTI is antibiotics. There's no evidence in this record that we ever paid for a single antibiotic. They did not obtain the payout records that would allow us to calculate the statute of limitations dates, because we don't know the payment of any of the date of payment of any of these bills. There's no payout ledger to establish that we paid for any of the treatment for the UTIs.
Yeah, but I'm talking about a medical question. Are you standing here today saying that someone who's lost their kidney and maybe having urinary tract infections, that there can't ever be a correlation there?
I don't know if there's a correlation. I don't accept.
But I thought I just heard that this woman has been getting the treatment from the same physician for her kidney and for the UTIs, and that's been covered.
The annual visits, the visits to the doctor are covered, but Judge, the way the world works and the way doctors work is they often treat for multiple conditions, or they'll list multiple conditions. They may have said every single time she has high blood pressure and diabetes. That doesn't mean that's a compensable condition. And what the key is in this case for whether treatment was furnished, was number one, did we furnish and it's only 2 visits, Judge. Okay, the last visit we paid for was for a date of service 1/29/2019. So we're talking about 1 year after that. Okay? There are 2 visits. One on August the 1st and one on August the 12th. They're at page 128 and 131 of the record. There is no mention of her kidney in either of those reports. There is no diagnosis of a UTI in either of those reports. There is no provision of any treatment or prescription of medical care for in those 2 reports. What she does is she comes in and she says to the doctor, it's at page 131 of the record, she says, I'm treating with someone else for a UTI. I'm on prescription medications that I got somewhere else, we don't know from where, and I'm having pain in urination, dysuria. And the recommendation in the report is, well, keep taking the medications you were given somewhere else. And then she follows up, August the 12th, I'm still having painful urination. And they tested her, negative for a UTI. She did not receive treatment for a UTI and definitely didn't receive treatment for her kidney in either of those visits. And the burden of proof, the way the statute of limitations works is they ask for care. We look at it and go, it's been more than 1 year. You're not getting care. So they file a petition. They did so in this case. Your cases say, well, the statute says, our obligation at that point is to raise the statute of limitations defense in the first response to the PFB, which is exactly what we did. They agreed. And then your cases say, where the claimant seeks to extend or avoid the statute of limitations under 440-19-2, which is the furnishing of medical treatment, she bears the burden of establishing the exception. And we've got a bunch of other cases that talk about how you do that. And, for example, in the Taylor case, you say, we reject the claimant's argument that by merely visiting the authorized physician, it's sufficient. You have to prove that you received treatment for the compensable condition. I deny that UTIs are compensable in this case, but even if they were, she did not receive authorized care. It was not furnished.
Okay, so you're saying there's no evidence in this record that you've ever paid for anything related to a urinary tract infection?
I do. What I say, Judge, is she is an authorized doctor. She goes each year for the kidney follow-up. We treat that. We pay for that. And he does mention from time to time she has recurrent UTIs. There's nothing in this record that says those UTIs are causally related to the kidney.
But she's going there for her kidney. She's not going there for something else on a part of her body. And I mean, I don't understand.
Aren't you, Judge?
I am
with all
judge,
due respect,
yeah.
are you assuming
No, I'm asking you a question. I just want an
by the
answer.
kidney removal? I'm just asking.
I'm asking you the question. You seem to be standing here today saying that there can never be a urinary tract infection associated with the kidney. And I think if that's your position, you're going to lose a lot of credibility.
No, I'm not saying that, Judge. What I'm saying is it's their burden of proof. It's their burden of proof. They're seeking to avoid the statute of limitations. Your cases say that it's the claimant's burden of proof to prove that that treatment that was received on that day was causally related, and she did not receive treatment for UTIs on that day, even if you're right, and the UTI is compensable.
Didn't the employer already approve a course of treatment, and the doctor was these annual visits part of the course of treatment?
The annual visits were paid for every single time until the statute of limitations ran.
Right. It was part of a course of treatment. I mean, she's had the operation, and there's this follow-up, I guess, that's been approved and accepted. She's going to continue to go back to a doctor for an annual visit.
Correct.
Right? But is it your client's position that if she doesn't get in there within 365 days, she's out of luck?
That's the law, Judge.
That's not the law. I mean, that's not what the statute says. I mean, the statute talks in terms of provision of treatment.
Right.
And then the year tolling runs from a payment, let's just say, or from the provision of treatment. But why can't the course of treatment, the provision, the agreement that you're going to provide annual visits, the provision of treatment.
Okay,
Why does there have to be this gotcha position where if you don't get in exactly 365 days, and I thought I saw there were a couple years where it was like 367 days maybe, or 368 days. Are you really taking the position that, sorry, you don't get, you have to come exactly every year, or you're out of luck?
Your Honor, that question has thrown me for a loop, because I've been doing this job for 33 years, and the statute of limitations, the law is, and it's the statute in your cases, that in order for the statute to be told, the carrier must furnish treatment within 1 year of the last authorized treatment. And so if you don't see a doctor within 365 days, yes, the statute of limitations runs.
So if the course of treatment and the doctor says, I'll see you in 18 months, and every 18 months after that, you're just going to cut off that course of treatment?
Absolutely. If the doctor says I need to see you in 5 years, the statute of limitations runs.
And well, let me push back a little bit more on that. So, I mean, the statute doesn't speak at all about actual course of treatment. It talks in terms of when can you file a petition for benefits.
Right.
And it says that no employee can file any petition for benefits, after the statute of limitations runs, which has nothing to do with the provision of care. It doesn't govern that. So I don't understand how an employer carrier can take the position, like a legal position about statute of limitations before there's a PFP filed, and say, we're just not going to continue with our course of care, which we've already approved because you're outside the year, based on nothing in the actual statute.
Okay,
in that respect.
let's go back to the beginning. The statute of limitations says your petition for benefits is barred within 2 years from the date of accident, but it can be told in 2 ways. 1, we pay an indemnity benefit, or 2, you receive authorized care. Okay? And you get 1 more year from the date you receive authorized care, or from the date that we write the check for indemnity benefits.
Well, it's actually a little bit different. It says it's told for a year, so you get 1 year on top of whatever period of time.
Correct.
There's 2 years that hadn't run yet
Right.
before the provision of benefits.
Right. The shortest it can possibly run is 2 years.
Sure.
You're going to get at least 2 years, right? But if I go, 18 months in and I get treatment, now I'm going beyond 2 years because I've got 1 year from that date.
Well, you got 6 months plus 1 year.
Correct. And then once I go again in a year, I get 1 more year. And once I go in again in a year, I get 1 more year. But if I miss a year, then my statute of limitations runs.
No, it would be, in that scenario, you'd get, after 1 year, you still get another 6 months. If you file your claim, or if your benefits are provided
Right.
18 months after the accident, you still have 6 months from the date of within that 2-year statute of limitations. And that is told, which means that it stops running.
Right.
And then you get 1 year on top of the 6 months.
Totally agree. Let's
Okay.
add that year in now.
Right.
And if I don't provide any care within that year, then the statute of limitations runs.
No, you still got 6 months, because the 6 months would then start running again after the tolling, the 1 year tolling. And I'm curious whether your claims adjuster worked that into the calculation before she denied the benefits 1 day after the 1 year ran.
Well, we don't know because we don't have any information about payment dates.
Is that, though, is there anything in the record that indicates that she was looking at that, or did she just base it on this 1 year period of time?
I don't think there's anything in the record that would differentiate between those two things. I do know that they took her deposition, and they could have asked about payment dates. They took her deposition, and they could have asked for the payout ledger to be attached to the deposition, but they didn't. And Your Honor, the main concern I have with the questioning is it seems as though I'm being queried as if my client had the burden of proof with the statute of limitations. This is a statute of limitations defense. It is their burden to prove that tolling applies.
And that would include submission of, like, the payments going back and establishing when the tolling started and stopped.
Right, to talk about how do we calculate this date or that date, 18 months, 6 months, how long do we toll it? And there's nothing in this record that would allow you to make that conclusion.
What's your response to your opponent's position that none of that matters because it's just provision of care, and we don't have to look at payments, or we don't have to submit evidence regarding payment dates or anything like that?
Well, Your Honor, I don't think that that's in compliance with the statute, and I reject that position. They have the burden of proof, and I simply think that they didn't meet their burden of proof to establish that the statute was sufficiently told, because that's the argument, was the statute told or not? And I think we need more information for you to make that conclusion, and I'm not the appellant. I'm not asking you to do anything other than affirm what the JCC did. So if there are no further questions?
Well, let me ask you this.
Sure.
Ms. Ortiz has been getting this care for her kidney condition for many years. I guess it's your position now that, too bad, we're not going to provide you any more benefits into the future. Is that correct?
Your Honor, that's exactly what the statute of limitations is
Well,
for.
I'm just asking, that's, your client will not pay another dime for Ms. Ortiz because of this situation.
Absolutely. That's our position.
So she's lost everything because of this billing issue or however.
And Your Honor, it happens thousands of times a year. I mean, that's
Disheartening to hear.
Well, I'm sorry, Your Honor, but if the legislature wanted an injured worker to be able to receive medical care for the rest of their life without limitation, the legislature is free to modify the statute and eliminate the statute of limitations.
Okay, so now if your worldview is correct, physicians should start bringing scheduling visits every 6 months, whether they're needed or not, because that will ensure continuity of care and payment. Is that, I guess you'd say, well, if that's what the legislature wants, then that's their problem.
Your Honor, I'm asking you to apply the statute as written and not the statute as a reviewing court might prefer it to be. And you know, it is easy to cherry pick things in the statute and say, well, I don't think this benefit is generous enough for injured workers, or I think this one's too generous. And I respectfully suggest that the court's role is not to increase the generosity of the workers' compensation system or to decrease it based on the court's perception of how the law should be.
I think we've all been schooled in that, counsel. We've heard that before. Thank you.
Counsel, this is a closing question. Is the statute of limitations, such as it is, or the 1 year, or whatever you want to call it, the running of that period of time, is that the sole basis for the denial of the claim?
No, because in the pretrial stipulation, the lawyer that tried the case also alleged that the UTIs were not causally related and that was not a compensable condition. In fact, they've never claimed at any time in any petition or anywhere else that the UTIs were compensable. They didn't claim it in the pretrial. So, no, I don't think that it's just the statute of limitations. I think there was a causation issue as well.
Thank you.
Thanks.
In rebuttal, I have to stand by the findings of fact by the judge. He found that they authorized the treatment in 2015 when it began for the pyelonephritis and the recurrent infection of the urinary tract, which of course is connected to it. The judge found as fact that she had 8 visits between then and 2020 for those conditions which they authorized, and there was no 1 year gap between the visits, so that the petition for benefits was filed within a year of medical treatment that was authorized and furnished by them. And that's what this is all about, because the issue of authorization takes care of causal relationship. The authorization shifts the burden by decisions, and it must be this way for them to disprove causal relationship. Otherwise, an employee would have the burden of proving that every visit to the doctor is related. That's absurd. So I stick by the judge's findings of fact. It was his conclusion that was wrong, because he stated the law, well, backwards by saying it was the burden on the claimant to prove that the medical care was related, When it was authorized, the claimant doesn't have that burden. The law says it shifts to the employer carrier to disprove it, and there was no evidence of it one way or the other. They did not sustain their burden, and for those reasons, the judge should be reversed.
Counsel, though, if the burden is on the claimant to establish facts, submit evidence to establish facts that are relevant to the tolling and the running of a statute of limitations, we're dealing with really ambiguous periods of time. So we know that the accident happened in 08, and there was treatment. There's stuff that happened since then. She moved to Orlando a couple years after that. Then she's getting all this other treatment. And we have a series of years, and there are medical records that show some of those years. But then we know that there was a year and a day following her last paid treatment. So on January 29, 19 is when the employer carrier says you're done. But then there's another few months before there's even a PFP filed. So now we're dealing with, we have to figure out, well, it's not just a year, over a year of tolling, but also how much time ran from the original accident and now a few months after the tolling stops running. And we have no evidence in the record showing us any of the payment dates or any of the relevant stopping and starting of the tolling.
I stand by the judge's findings of fact. He found that they paid through January of 2019. That's in the record. It's in his order. And then that's when the doctor's office, although the medical care was furnished and it was authorized, sent the bills to the group insurance carrier. And of course, the doctor sent the bills in 2020 that she got in June, but she didn't do anything about it until August when she denied.
Your PFB was filed more than a year after the last payment that you're relying on in the record.
You heard them say, and the statute begins with 1 year from the furnishing of the medical treatment. And they furnished medical treatment that was authorized without a 1 year gap, and the judge found as fact that that is the case. The reason it hasn't been, quote, paid by them after January of 2019 is because the bill hasn't been sent to them and they haven't denied it. But it was still furnished, and that's what the statute says. And the statute was clearly does not bar this case. When she filed the notice of denial in August of 2020, and the PFB was filed 3 weeks later. Thank you, Your Honors, for your time and attention.
All right, we are going to take a short recess. Join us for coffee in the Rotunda.
All rise.
Orange County. And Ms. Oliva, you ready? Okay, you may proceed when you are ready.
May it please the court, my name is Megan Oliva and I represent the appellants in the present appeal. I'd like to reserve 5 minutes for rebuttal.
Okay.
Your Honors, this case involves a former Orange County employee who filed a claim for benefits for his coronary artery disease pursuant to the presumption statute found in section 112.18 Florida statutes while he was still employed. To provide some background, the claimant had worked.
Can you pull the microphone a little closer, maybe up?
Yes.
'Cause
Is that better,
there,
Your Honor?
that's better, yes.
Perfect. To provide some background, the claimant had worked as a firefighter up until April of 2019 when he went out on medical leave due to a personal medical condition. In June of 2019, he developed a second personal medical condition, and by July of 2019, he was aware that his medical conditions would prevent him from ever returning to work as a firefighter.
Were the medical conditions at all related to the presumption that we're talking about in this case?
No, Your Honor. They were not related to his heart at all. After being placed on medical leave, the claimant after he was placed on medical leave, the claimant was no longer subject to being called to fight a fire and no longer had any firefighting duties. Several months after.
What was his position, though? I mean, he was on medical leave, but what was his, I think you said in your brief that he was employed by Orange County still. So if he was employed by Orange County, employed as what?
Well, his official job title was firefighter at the time that he was out on medical leave.
So you acknowledge that he was employed as a firefighter even when he was on leave?
He was a firefighter in one sense. However, Your Honor, the issue in this case is whether or not the claimant qualified as a firefighter pursuant to the definition contained in section 112.191, subsection 1 Florida statutes. So obviously, this court has held in Smith versus City of Miami that the definition of firefighter contained in section 112.191 is the one that's applicable in cases under the presumption statute. So that section defines firefighter as any duly employed uniformed firefighter employed by an employer whose primary duty is the prevention and extinguishing of fires, the protection of life and property therefrom, the enforcement of municipal, county, and state fire prevention codes, as well as the enforcement of any law pertaining to the prevention and control of fires, who is certified pursuant to 633.408, and who is a member of a duly constituted fire department.
So when he was hired as a firefighter by Orange County, did he have a different set of duties than what was listed there?
No, Your Honor. When he was first employed as a firefighter, those were his responsibilities.
And that is the official, probably the official duty list, or, you know, the KSA is listed for that particular position.
Yes, Your Honor, and he held those responsibilities up until July of 2019.
So your argument was because he was out on health care leave, that he was not a firefighter during that time when he was on medical leave?
Somewhat, Your Honor. So the argument here.
So what if he was on vacation? What if he, took 2 weeks off and went to Europe? But was he a firefighter then?
Yes, Your Honor, but the position of appellants in this case is that once he became aware that his medical conditions would prevent him from ever performing those duties listed in the statute, then he was no longer considered a firefighter pursuant to that statute.
Why would it be in his mind that he has to, I'm not sure I can be a judge anymore. I can't be, what does that matter, what he thought? Wouldn't it have to be the objective evidence that he can no longer perform the duties of a firefighter, that someone else makes that determination?
It was because of his medical conditions that he would no longer be able.
Well, if they went through the process to medically discharge him or to transfer him to the Parks and Recs department, but he was still on the books as a firefighter. And he was just merely on some of the myriad kind of leave a firefighter can get.
Yes, Your Honor. And this court has held on multiple occasions that any non-retired firefighter is entitled to the statutory presumption. And in those cases, which were City of Clearwater versus Carpentieri and St. Lucie FCRD versus FMIT, this court focused on the first part of the definition in 112.191, that any duly employed uniformed firefighter employed by an employer. That was the focus of this court and the lower courts for those cases. For reasons unknown, the second part of that statute, that the firefighter have those primary duties, wasn't addressed. And in fact, those two cases, the Carpentieri and St. Lucie, don't even reference Section 112.191, and this court has held that you have to satisfy the requirements of that definition of firefighter to be entitled to the statutory presumption.
Isn't that the section, though, that says as used in this section?
Yes, Your Honor, but this court held in Smith versus City of Miami that that definition should be applied when considering whether somebody is a firefighter.
Sure. I mean, even though the actual statute we're talking about actually has moments where it does cross-reference other statutes and definitions, but not this particular one.
Correct.
I guess what I'm asking is, any reason why we shouldn't, reconsider, like, looking at that other statute that's not related to this particular one for the definition?
I mean, this court, of course, is free to do so, but based on the case law currently in effect, a firefighter can only be entitled to that presumption if they satisfy the requirements of 112.191.
So if he wasn't a firefighter, what was he?
He was an employee of Orange County.
In what
Just-
position?
And his official job title was firefighter. However, somebody can be a firefighter but not satisfy the definition of firefighter as contained in Section 112.191.
Didn't his chief tell him, like, well, we'll keep you on so you can see if you can find a different position or different duties?
So he did go through the medical separation process, and ultimately he was medically separated from the county.
Right, but before that, didn't they give him an opportunity to see if he could get hired or do something else that was commensurate with his abilities?
Your Honor, I believe that the claimant would have been entitled to his options within the county, but that wasn't actually at issue in this case. He had some severe medical conditions that prevented him from working as a firefighter, and so the decision moving forward was to medically separate him.
But if what you're saying is true, that even though you have the title of firefighter, you can do pretty much anything, and it's what you're actually doing that matters, not what your actual title or position or what you're getting paid to do that matters.
Yes, Your Honor.
Why did they have to medically separate him? Why are you going to say, hey, we got, we have in sanitation, we have positions and everything else. We need someone to, work in sanitation. You can just go over there. You can be a firefighter. You can have the title. You can just go over there and do something, or a desk job in sanitation.
I mean, that
something
is
like
certainly a possibility. And
So what about a firefighter that's made the public affairs officer that basically just goes and talks to radio stations and first grade classes? They're not fighting fires. Are they covered?
Well, I mean, they are subject to being called to perform these duties, right, as listed in 112.191. So in this case, this firefighter was not subject to being called. Both the claimant and his supervisor testified that he would not be subject to being called to perform any of these duties. In fact, he wasn't even physically capable of performing these duties beginning in July of 2019.
Does it matter that they viewed it as something permanent rather than something temporary? Like he had appendicitis and he had to have his appendix out, and for 2 weeks he couldn't work. Would he not be covered during those 2 weeks?
No, he would, in that situation, Your Honor, I believe he would be covered because he would be capable of returning to perform those duties as listed in the statute. Our position is that once a claimant becomes incapable of performing those duties listed in 112.191, they can no longer be considered a firefighter pursuant to that statute. Now, Your Honors, even if
So there's no responsibility for some kind of hearing or adjudication. Soon as the employer decides that he can't fight fires, he's not covered.
if he is permanently prohibited from performing those duties, then yes. I mean, he can still carry the title of firefighter, but he doesn't qualify for the statutory presumption.
Can you turn to the presumption part of it and explain why you think, well, first, tell me which type of presumption are we dealing with and what are you arguing?
So Section 112.191 says that any, in this case, firefighter who can prove 4 elements.
Well, yeah, I mean, I know what the statute says. I mean, when I say what type of presumption, it sounded like in the brief that you're arguing for a vanishing or a bursting presumption, that sort, as opposed to, you know, a public policy presumption.
Right, it is the first, as you mentioned. So if the claimant satisfies all of those elements, then the burden then shifts to the employer to prove that a non-work-related condition caused the heart disease or hypertension at issue. And in this case,
Well, actually, under a bursting presumption, like, what it sounded like you were arguing in the briefs is after you submitted some evidence from your expert that it was a genetic causation, that now, and that's where the JCC erred, because they didn't then start looking at all the evidence. They just rejected you out of hand, which then sounds like a vanishing presumption, which sounds a little bit different than Ratliff and that line of cases.
So, I mean, the statute says that if the claimant presents evidence of that they've satisfied those first four elements, the burden then shifts to the employer carrier to prove that the non-work-related condition caused the heart disease or hypertension at issue.
Prove or submit competent evidence?
I'm sorry?
Prove or submit competent evidence? Which are you arguing?
It's the standard is competent evidence.
Right.
If the claimant does not present any evidence to support the statutory presumption. So in this case, it was competent evidence. And this case is.
Let me get this. Once the claimant establishes that they're eligible for the presumption, they have the presumption.
Yes.
But it's a rebuttable presumption.
Yes.
But the employer carrier has the burden at all times to rebut that presumption.
Yes.
Okay.
And they have to present competent evidence to rebut that presumption if there is no evidence presented by the claimant. And now.
But what happens after that, though? What happens after, let's say, your doctor, with his opinion, that it's genetically, there's a genetic causation or a history of genetic, some sort of genetic relationship with the heart attack and the heart disease. Does the JCC then just weigh the evidence to determine whether the claimant has presented medical evidence of work causation, or is it still a presumption and you are accepting it's still a weighing exercise with your client always bearing the burden like Judge Roberts just mentioned?
The judge has to determine whether the employer servicing agent presented competent evidence sufficient to rebut the statutory presumption. Unless the claimant submits evidence.
But they maintain the burden at all times.
The employer does.
Right.
And then if the claimant submits evidence in favor of the presumption, then the burden becomes more significant, clear and convincing evidence. And
so you're not trying to rely on the Florida Supreme Court's position or holding in Universal, which got rid of Caldwell and talks about public policy versus non-public policy presumptions. You're not arguing for a change in Ratliff or anything like that?
No, we are not. In this case,
But then if you're not going to take that position, that puts you in the position of just saying we should second guess the JCC and the JCC didn't adequately weigh the evidence.
Well,
and that's
Your Honor,
a really hard burden.
It is a hard burden, but in this case, the JCC erred for multiple reasons in finding that the presumption had not been rebutted. Now, the issue of rebuttal in this case is different from your typical risk factor argument in coronary artery disease claims. And what I mean by that is employer carriers can often present evidence that somebody's high cholesterol, diabetes, history of smoking, all combined to cause the claimant's coronary artery disease, and then the judge has to determine whether or not that's sufficient to rebut the statutory presumption. In this case, the undisputed medical evidence is that if the claimant has the condition familial hypercholesterolemia, which is a non-work-related genetic condition, then that is the cause of his coronary artery disease and subsequent heart attack. Here, the judge made a medical decision on her own. She determined that the claimant did not have familial hypercholesterolemia, which is an opinion that finds absolutely no basis in the record. And, Your Honors, we're aware that a judge can reject unrefuted medical evidence provided a sufficient reason is given. But this court has held that when a medical question is presented, a JCC cannot substitute unrefuted medical evidence with his or her own opinion, and that's unfortunately what happened in this case. The
Is that
judge-
even the case, though, when, I mean, because you're accepting that there is a lingering presumption in favor of the claimant at all times and not a vanishing presumption, is that the case in that with the lingering presumption situation? That you're saying the JCC still has to provide a reason why she's accepting the presumption and is not convinced by the employer's evidence?
So the argument here is that obviously the claimant does not have to present evidence that in support of the presumption, but her decision to reject the employer carrier's rebuttal argument should be supported by competent substantial evidence, and it was not in this case. She completely misinterpreted Dr. Nasro's
Well,
testimony.
the presumption always stays with the employer, correct?
Employee.
The employee gets the presumption, and it has to be rebutted by the employer.
Correct.
Okay, so she hears what the doctor says.
Correct.
And she says, that sounds kind of weak to me. I don't find that terribly compelling. And says that the presumption in favor of the employee still lies. How's that not correct?
Well, Your Honor, she was making a medical opinion when she stated that the claimant did not have familial hypercholesterolemia. And
So
that
if you have a doctor come in and say it, the only way to reinstate the presumption is to have a doctor on the other side? Is that what you're saying?
The claimant obtained an IME. The IME said he didn't know what the cause of the claimant's coronary artery disease. The authorized provider in this case says it's the familial hypercholesterolemia. He has this condition.
Okay, so the IME said there's no way for a doctor to determine what caused it, so that means the presumption still exists.
Well, this court has held that under similar circumstances where one doctor has stated that they don't know the cause and another doctor has opined that this is the cause, that it is error for the judge of compensation claims to reject the unrefuted medical evidence.
See, and that goes back to one of my first questions to you, which is I don't understand why you're not arguing that Ratliff is wrong. Because what I hear you saying and what I heard you saying in your brief, it sounds a lot like a vanishing presumption. You're arguing the JCC erred because your client presented opinion testimony that says it's genetically caused, and the claimant didn't present any evidence that of industry-caused, industry-related causation. And that is a vanishing presumption argument, not the JCC erred because she shouldn't have weighed the evidence or something like that.
So in that case, in my reading of Ratliff, the first DCA, this court, found that it was error for the JCCU to use the catch-all phrase, whatever the standard may be. But then those facts that are specific to this case is that, they found that that you have to have competent substantial evidence to support the decision that the presumption had not been rebutted. And that is exactly what we're asking this court to do in this case. And, Your Honors, the final point on appeal was that the appellants, or that the JCC erred as a matter of law in concluding that the claimant's hypertension needed to be treated under the hindrance to recovery theory because there is absolutely no medical evidence in the record stating that the claimant's hypertension was serving as a hindrance to the recovery of his coronary artery disease. In fact, he was already at maximum medical improvement, so the hindrance to recovery doctrine wouldn't even apply. We ask that you reverse the JCC's order. Thank you.
May it please the court, my name is Kimberly Hill. I'm here on behalf of the appellee, in this case, Mr. Christopher Holt. Your Honors, this court long ago established a bright line rule as to whether or not Mr. Holt, in this case, would be a covered employee. And he was a firefighter. He was a firefighter until the day he was medically separated. And actually the first case was Smith, which was referenced earlier. In that case, some language was used, and that's not in the statute, but this essentially formulated the reason why this court has maintained this position throughout several cases, and that is And the argument that I didn't hear mentioned today, but is mentioned throughout the briefs of the employer carrier, is that the claimant had to be on active duty status. And by active duty status, they're reading that to mean that the claimant actually had to be able to do the firefighting duties at the particular time that he had the heart attack or the covered event. And actually, this court has determined that the active duty status means retired versus not retired. And that was carried through in the Carpentieri case as well, where this court specifically set forth that, and in fact rejected a very similar, well, the exact argument really. The court said, simply put, this court, I'm sorry, I'm reading from the wrong case. EC argued that the claimant wasn't on active duty at the times, and this court rejected, noting, we find the issue should be framed simply in terms of whether the claimant was or was not retired.
Why do you think that that makes a difference? Like, what other than it just being an arbitrary line?
Well, because this is a policy. The whole Chapter 1, 1218 is a policy provision.
Right, but the statute doesn't make that policy line. It's apparently this court that's made that policy line, which
right,
doesn't sound like something we should be doing, but.
But then the legislature never changed it over
Sure.
all the years as well, and they certainly have the opportunity. And in fact, in Smith, they were invited by this court
the
to-
legislature made the decision that, that if you're fighting fires, the stress of the fire puts you at grave risk of heart disease. And, we've known that that's not true since the 50s probably. And the legislature's never changed it. And, but this court comes in and says, oh, we abhor irrebuttable presumption. So we've lopped it off and lopped it off when largely I think the intent of the legislature is they just wanted to give a perk to firemen.
Well, they might, but the legislature's,
But this court
there's still a presumption.
is gone so far away from there that's
Right, I mean.
not material anymore.
We're still bound at this point to essentially follow what the legislature has set forth. And, I mean, it was carved away at, I know that. If you take it all the way back to Caldwell, where it seemingly was clear and convincing evidence, if you read Caldwell, but then it was changed, I think it was Punske, I can't even remember, but it changed subsequently to be just, if the claimant doesn't put forth any additional evidence to prove causation other than the presumption, then the carrier only has to overcome the presumption by competent evidence. But nevertheless, the claimant
None of which is actually found in the statute, by the way.
Right, none of it.
But
None of
but with respect to Caldwell, though, and that was my question to opposing counsel, let me ask you this: why should 9303 apply versus 90.304, or 9304 versus 9303, the rules of evidence? Like, why? What's the argument for why it should be a public policy presumption as opposed to a bursting presumption or vanishing presumption?
Well, I mean, that's just because that's the way the statute is structured. I mean, it always has been the same way, and the legislature could opt to change it if they didn't agree with Your Honor or this court's decisions, and they have never opted to change the statute. It remains the same.
Sure, but
In fact, they extended it to police
Cancer.
officers and paramedics.
Oh, right,
and all kinds
and they've extended it
ambulance
to other
driver- yeah.
conditions now, cancer, PTSD, et cetera, for
Would you-
certain.
Would you acknowledge, though, that the statute nowhere expressly states that this is a policy matter or that it's a policy-based presumption? Would you agree with that?
That the statute doesn't say
Right.
it? Well, the statute definitely doesn't say that it's a policy-based presumption, but
Which is what
the court's
Universal actually
decision-
requires.
The court's decisions have said over and over again that it's a policy, policy presumption for protection of firefighters and they, essentially because of the, the stress that they're under over years of service, not just, that's known presumably to cause heart attacks, high blood pressure, and other such things that are mentioned in the statute. So yes, there is a policy provision there because they are exposed to things that, us as, judges or lawyers or whoever else are not exposed to on a day-to-day basis.
Did the way the JCC handled the employer's doctor in the opinion testimony there, could that be construed as a determination that it was like rejecting it on Dauber grounds?
I don't think she was rejecting it on Daubert grounds. It probably should have been rejected on Daubert grounds.
Because, I mean, because I'm curious whatever happened with the Daubert objection to that testimony.
Right. I don't think she ever, if I recall, Daubert wasn't raised on appeal and a cross appeal, but I think she rejected the Daubert objection, if I recall right.
So doesn't that make it competent evidence in the sense that...
It's a competent evidence question. And
well, no. I mean, isn't competent evidence have to do with whether it was admissible? And it obviously was admissible because the JCC didn't reject it or sustain the objection.
Right. I mean, it did come in because the
Right.
JCC denied the Daubert objection. From what I recall, I didn't really focus on Daubert here only because it was rejected and it wasn't taken on cross appeal. But the judge still has the obligation to make the determination. It's not just a question of whether or not the employer carrier puts forth what they feel is competent evidence. The judge has to feel is competent evidence to overcome the presumption. And in her mind, she went back and looked at all the different factors. It's not just a matter of the doctor testifying that this is a genetic condition. I mean, and he said it was a genetic condition, but then the things that he was relying on to say it was a genetic condition weren't part of the facts. And one was the parents. Neither one of the parents it wasn't in the medical records that either of the parents had this condition. He didn't have the cholesterol deposits. He didn't have genetic testing. He didn't have any of the things the doctor was relying upon.
But isn't that precisely what Daubert is? I mean, that is a Daubert question. The reliability of the methodology that the doctor is applying to reach the opinion that he or she offers. And,
That is what
apparently the JCC accepted that opinion testimony because the Daubert objection was asserted. At the final hearing, it was mentioned that there was a Daubert objection to his testimony, and the request was, Judge, please just address it in your final order.
Right. It was admitted. There's no question about
Right.
it. So, but that doesn't mean she has to accept it. I mean, it still has to have a factual foundation, which it didn't have. I agree. That is a Daubert-type objection, and that is part of the Daubert standard as well.
But there's no contrary, I guess, I mean, this is what I think what opposing counsel, the point that she was trying to make is that, but there was no other medical evidence in the record to suggest that that opinion was wrong.
Well, the opinion can't stand in and of itself to support, a factual determination that he actually had the condition. But there was no other evidence, but there doesn't need to be any other evidence. The judge comes in, the presumption is there, it stays with the claimant unless the judge finds that the employer overcame the presumption by competent evidence. And it has to be testimony that the judge finds acceptable to overcome that presumption. In this, otherwise, there's no reweighing of the evidence. And I understand what you were saying about Ratliff. This is different, and actually what
And
my
the fact
opposing-
that the judge found that evidence admissible does not mean it met that standard.
Exactly. She doesn't have to accept it just because it was admissible.
But what do you think accept means? I mean, it's in the record. It is evidence, and it hasn't been rebutted. It is an opinion offered by a doctor. The Daubert objection was made. It was not sustained. It's part of the record, and there's nothing else contradicting it. And so for purposes of this question of, well, we don't reweigh it, what makes the JCC better positioned than us to look at the same deposition testimony and come to a different conclusion?
Well, because that's the judge of compensation claims job. I mean,
To do what?
Essentially, there were a couple of cases back in the day that I recall where there were depositions and the court was kind of looking into it and more or less reweighing the evidence based on deposition. And there was even an opinion out there that said that the court could look at the depositions if it was by deposition versus live testimony. And this is in workers' comp cases I'm talking about. And, and eventually the court receded from that notion and said, we're not reweighing the evidence. This isn't happening regardless of whether all the medical testimony is presented by deposition. The judge is in a unique position to review the evidence before him or her, and this court really isn't, obviously there's a million cases that say we don't reweigh the evidence. That's
Right, but
that's not our job.
But reweighing would assume that there's evidence on the other side to compare.
Okay, I understand your point.
So what did the judge weigh?
There doesn't have to be actually, if the judge just doesn't believe the testimony, the judge has the authority to reject even uncontroverted testimony. There's a lot of case law that says that.
But
in
what
workers'
is,
comp
how do you
cases.
believe or not believe an opinion? Like what, I don't understand how that works. If it's already admitted, so it's not a question of whether it's reliable, it's in. So it's an acknowledgement that the methodology was reliable. The JCC has skipped past the gatekeeping role. It's in evidence, and there's nothing opposed to it. How does the JCC say, I just don't believe that opinion? On what basis?
Well, on the basis that the facts don't support it, the underlying facts don't support the opinion. The doctor admitted there was no family history in his records of this condition, which was one of the primary reasons. The other one was that the cholesterol had to be over 180 on a consistent basis. There were 15, I guess, records of cholesterol tests, I think less than half of which were over 180. There was also no cholesterol deposits on his eyelids or on his elbows or on his skin anywhere, and there was no genetic testing. And the doctor was relying on, I forget what it was called now.
And the judge didn't have to find it was, the medical testimony was completely unreliable. The judge just had to find it wasn't persuasive enough to overcome the presumption, right?
That's exactly right.
What would what would be enough? Like, what would a persuasive opinion from an employer look like? I mean, qualitatively.
Well, I guess one that, in this case, I'll give you the example. If the family had this condition, the mother and father, as the Dr. Nacero was stating, was one of the requirements. If he had consistently elevated cholesterol levels over 180, if he had cholesterol deposits, if he had even genetic testing, which was an alternative mode the doctor was suggesting, that could prove that, in fact, this condition was genetic, that probably would have been a good start or enough, to overcome it. But when the facts don't support the opinion, then
It shouldn't be admitted.
Well, it may not. Maybe it shouldn't have been admitted, but
Well, couldn't you have a situation where there's 5 factors that were relied upon to come up with this opinion? And there's only really 2 that may have some marginal impact. So I'm the trial judge, I'm going to let it in, I'll admit it, but that doesn't mean I'm vouching for it to be the most persuasive, credible opinion. I may say I'm going to let it in, but when I look to analyze it, well, only 2 of the 5 factors are present here, and one of them is kind of marginal. So it's of marginal value. I'm not going to allow the presumption to be overcome. Another situation, maybe all 5 factors are present for the opinion. It's a very powerful, persuasive opinion, and that's going to be a more difficult situation. But this case is more at the other extreme, isn't it, where it's a marginal persuasive value, what was put in as the expert opinion.
very marginal. The only thing the only thing that was present was his age at the time of the first heart attack, and you might want to count those as 2 because the doctor said age and then age at the first event. So
I'd be a little worried if we created a rule of law.
That's one.
The rule of law is that if it's admitted, then it has to be deemed persuasive and reliable, even in the absence of other evidence. Maybe that's what the rule we should have, but I think trial judges probably more often than not perhaps say, let it in, we'll let it shake out at the end, and we'll see how persuasive it is.
Right, as long as the judge gives an opinion, and there's many cases that say this as well, as long as the judge of compensation claims actually sets forth the reasons, not that they're necessarily required to set forth reasons in their order, but when the judge does set forth reasons, which in this case she did set forth reasons for the rejecting the opinion, then that's an opinion then that should be affirmed. But I'm thinking it's Ratliff. The judge did not put forth an opinion while she was rejecting the testimony, so this court reversed on its own, and because the judge just used both standards and some just general language and did not put the reasons why she was rejecting the testimony. And I think that's why Ratliff came out the way it came out. And in essence, this court, said that the claim that the employer carrier met the presumption in that particular case.
Well, what if the opinion had all the facts that you listed before? and the JCC still says, I'm not convinced.
Well, this court certainly would have the opportunity to say that that opinion wasn't based on competent evidence, but.
Well, I mean, she says, I mean, I know that the doctor opined, and, you know, these 5 factors are there, but like factor 1 is kind of weak. You know, there's only 3 elevated levels over the course of 5 years, and I really think there should be like 7 or something like that. And, only one parent had some genetic disposition. I'm not convinced unless there were 2 parents with a genetic disposition. So I'm going to reject the opinion and grant for the claimant. What would we do then? I mean, can we look at that opinion or that JCC determination about that opinion and come to a different conclusion, or do we have to accept it because she said a reason, even if it doesn't make any sense?
Well, I mean, you have the opportunity not to accept it, and that's happened in cases where, such as Ratliff, for example. I was sort of surprised by that decision myself personally. That it wasn't my case, but I'm just saying that this court made a determination based on the evidence before it versus reverse and remanding it back to the judge of compensation claims to make that determination and weigh the evidence and determine which standard actually applied, whether it was competent evidence or clear and convincing evidence in that case. And instead, she just kind of used the catch-all phrase and, and rejected the employer carriers.
Sure, but my hypothetical wouldn't be a catch-all. It would actually be a specific explanation from the JCC. Are you saying that in that instance, we are capable of looking at that and second-guessing the JCC?
I mean, my opinion is that not really. I mean, that is really reweighing the evidence. But, there have been instances, if there is no logic to support the judge's determination, where this court has reversed. But as long as the judge gives an explanation for rejecting even uncontroverted medical testimony, and the reason is logical, this court has always taken the position that it would affirm that type of decision.
Otherwise, we might as well just have all the depositions submitted to us, and we decide the case.
You review it yourself.
Which, in fact, is what happens most of the time in these cases.
Yes, Your Honors. If there are no other questions, anything else? Okay. We just ask that you affirm on appeal. Thank you so much.
Ms. Oliva, you tried to reserve more time than that, and at the very end, we asked you a bunch of questions, so I'm going to give you 2 extra minutes.
Oh, wow. Okay. Thank you, Your Honor. So as to the second point on appeal, Your Honors, it is unrefuted that if the claimant has familial hypercholesterolemia, then that is what caused his coronary artery disease and subsequent heart attack. And if that is proven, if there is a diagnosis, then the statutory presumption has been rebutted. And in this case, the judge of compensation claims made her own medical opinion, which finds no basis in the record that the claimant did not have that condition. And that was error. I mean, this court has held on numerous occasions that a JCC doesn't have the authority to render a medical opinion. That is the purpose of obtaining experts.
Are you making a distinction, though, between rejecting an opinion and, I guess, coming to a medical conclusion that he doesn't have it? I mean, I thought what she was saying is, I'm not convinced by this opinion for the reasons that your opposing counsel mentioned, which is, there's no indication of the parents having a genetic disposition and what have you, or the elevated levels, there's not enough of that. And so the JCC said, yeah, and that's kind of weak factual foundation for the opinion, so I'm just going to reject it.
Well, perhaps if there was evidence to support her opinion that, well, maybe he doesn't have the condition, but that's absolutely not in the record here. This isn't one doctor saying he has familial hypercholesterolemia and another doctor is saying that he does have it. There is only one opinion in the record, and that is Dr. Nassero's, and he says the claimant does have it.
But isn't the JCC entitled to look at the underlying facts on which he relied on to offer his opinion and assess whether, and you've heard all the argument here, so let's say the JCC provisionally accepts the opinion and then looks at the deposition transcript again and says, yeah, I kind of see where, there's these things missing, and that's a pretty weak opinion. He's just opining. It's almost pure opinion testimony.
Well, that's another place where the JCC erred in this case. If you look at her final order and Dr. Nasro's deposition, it's completely contradictory. She misinterprets it on numerous occasions. And, Your Honors, she completely disregards the diagnosis of familial hypercholesterolemia by the claimant's personal cardiologist, Dr. Batar, who had evaluated the claimant before a workers' compensation claim had ever been filed. She gave no reason for rejecting that diagnosis, which, and this court has held that the JCCs can consider fact-only evidence from non-authorized providers. She did not even acknowledge that diagnosis, and she completely misinterpreted the testimony of Dr. Nasro, and it's all outlined in the briefs, and a careful reading will show that the claimant did have familial hypercholesterolemia to a reasonable degree of medical certainty, and that the statutory presumption had been rebutted. I appreciate your time, Your Honors. We ask that you reverse. Thank you.
All right, thank you both for your argument. Let these lawyers clear the well before the next group comes up. Is everybody set? Is the appellant ready?
May it please the court, my name's Larry Carnes, and I represent the appellant.
Mr. Carnes, grab that mic and pull it closer to you.
That better?
Yes.
Okay. I represent the appellant, Rebecca Hernandez, and I request 4 minutes on rebuttal. Rebecca Hernandez is the daughter of Darlene Rice, who was a member of the Florida retirement system. In this case, the Department of Management Services seeks to deprive Hernandez of funds that were paid into the retirement system by her late mother. In a letter of May 10, 2019, the department claimed that she was only entitled to receive the money contributed into the pension plan after her mother transferred into the pension plan, and that she was not entitled to the money that her mother paid from her own money to transfer into the pension plan of $22,943.81.
But in that $22,000, doesn't that represent the amount that's necessary to make the pension plan whole, as if she had joined the pension plan from the start?
Correct. Yes,
Okay.
it is. But actually, that has nothing to do with the amount she's entitled to recover.
Well, let's say
by
she
death
had never
benefits,
gone
because it
in
came
the,
from her funds.
let's say she had never gone in the investment plan. She,
Yes.
on day one of her state employment, she said, I want to be in the pension plan. And unfortunately, she passed before she vested. What would she have been entitled to then?
If what? She'd solely been in the pension plan?
Yes.
She'd been entitled to all her contributions that she made, which were the money that she actually paid.
The 3% that the legislature now requires state employees to pony up to be in the pension plan.
That's correct. But in this case, she paid in addition to that. And in fact, the department has denied her the benefits that she actually contributed, the 3%, while she was in the investment plan. In fact, they've ruled it's the only
So,
amount.
so we have three groups of money we're talking about. We're talking about
Correct.
the 3% she paid once she joined the pension plan.
Correct.
We're talking about the money that was in her investment plan, the part of which was represented by the employer contribution.
No. We're not talking about that whatsoever. In fact, the three funds are the 3% that she contributed while she was a member of the investment plan, the 3% that she contributed while she was a member of the pension plan,
Okay.
and the $22,943.81 that she contributed of her own funds to transfer from the investment plan to the pension plan.
But the $22,000 that she was required to contribute to, because she cashed out her investment plan, put that money in there. Because her investment plan had not performed well enough in the market, there was a deficit. So
Correct.
the actuarial value of what she was buying into the pension plan was not covered by what she had in her investment plan. So the $22,000, at least, was the money required to bring her up to that actuarial value, right?
Yes,
Okay.
that's correct. But it didn't include the funds that the state contributed to her plan whatsoever. The administrative law judge held a hearing on July 2, 2020, and entered a recommended order on September 21, 2000. Basically, the administrative law judge determined that there are two statutes that apply in defining the member's benefits because she was not vested at that time in the pension plan.
What factual dispute did the ALJ actually resolve?
Section 121.091 paren 7.
That's a statute. That's a statute. But my understanding is the agency actually accepted all the facts that the ALJ found.
The what?
The agency accepted all the facts that the ALJ found, right?
They said that in words, that they accepted all the facts. In fact, their final order went against the facts from the testimony and that the facts that the administrative law judge actually found.
But weren't those the facts that the ALJ actually found? They accepted the ALJ's findings of fact.
They said that. That's what they said in their
Right.
in their final order.
And what the agency disagreed with was what the ALJ said about the law,
The what?
about the law, about the statutes themselves, right?
Yes.
Okay,
But-
doesn't the agency have that prerogative to disagree with the ALJ about the law?
They do if they can establish that their conclusions are as or more reasonable than the findings or conclusions of law of the administrative law judge. The interesting fact in this case is their brief doesn't even attempt to do that when they and to support their final order by attempting to say that it was as reasonable or more reasonable than the findings of the administrative law judge.
Well, I'm walking through 120.68, subsection 7, which cabins what were the bases on which we can set aside an agency order.
Right.
Are you asserting that the agency action depends on a finding of fact that is not supported by competent substantial evidence?
Yes, I'm saying that their
finding
findings in
of
their
fact?
final order
Which finding
went
of
against
fact?
the findings of fact.
Which finding
The-
of fact was not supported by competent substantial evidence?
Basically, the fact that the Kathy Gold, the Bureau of Chief of Retirement Calculations, testified that $16,042.58 was contributed by Rice, $13,388.41 in the investment plan, and $2,654.17 was while she was in the pension plan. That's at the record at 376.
Sure.
The transcript at 757.
Are you saying that's not supported by the evidence?
I'm saying it was supported by the evidence.
Right, and that's a
but the-
finding of fact that
That's
was
a finding
included
of
in the
fact.
final order.
But the final order disregards that finding of fact.
Well, that's disregards, which is different from relying on a finding of fact that's not supported. So the agency applied the law in a certain way based on the facts that were accepted by the agency. So then my question would be, another provision in 12068 is, did the agency erroneously interpret a provision of law?
Correct.
Okay. And what provision of law are you saying that they incorrectly interpreted?
Well, essentially, that the administrative law judge found that the members' death benefits were provided in Section 121.0917, that it was defined as the accumulated contributions. Section 121.02126 defined a member's contributions as contributions without interest subsequent to December 1, 1970. And then there were two rules, 60S-4.0081A said they're entitled to a refund of the member's accumulated contributions. And then Rule 19-11.0073, I think it's L, require a personal payment, basically. And the administrative law judge went on to conclude that the plain meaning of accumulated contributions was the whole monetary amount that Rice gave or supplied to the pension plan, and that there is nothing in the law or rules that states, either directly or indirectly, that a vested amount would not be recoverable. That's in the record of 390.
We're called upon then to determine what is a accumulated contribution.
Whether what?
We're called upon to determine, looking at the statute, what is an accumulated contribution, which is defined but not really defined. I mean, it's kind of hard to understand because it's not very specific, and that's what we're here today to deal with, right?
Yes.
Okay, so for the accumulated contribution, let's assume, so we're talking about the actuarial accrued liability, right? That's the sum that your client ultimately had to pay to get in the pension plan, right?
That's what the,
Okay.
yes.
Is there anything in the record that explains or provides in detail the calculus or the formula that breaks out how that determination or how that sum was arrived
Yeah,
at?
but I don't think it's relevant really to the determination of the death benefits.
Well, it would be relevant if
Basically-
we're trying to figure out whether the 3% that she would have contributed had she been in the pension plan all along, whether that was rolled into that actuarial accrued liability.
I don't read it that way. I read it that, number one, she actually contributed while she was in the pension plan. She actually contributed the 13,000 some figure while she was in the investment plan, and she actually contributed the 22,000 plus figure when she transferred into the pension plan from the investment plan. Because if she would have died as a member of the investment plan, she was vested automatically from the day it started. So those funds would have been hers in any event.
Sure, whether they gained or lost, she would only get
What she put in.
Yeah.
Exactly.
Plus the either the accumulation or the
But for the pension
downside.
plan, she had to be there 8 years. She was a little short because she died within a year, or less than a year, from the time she transferred into the pension plan. But the funds that she actually contributed, the 22,000 figure, was actually a contribution as defined by the administrative
So under that theory,
law
why
judge.
aren't you claiming the whole
The what?
under that theory, why aren't you claiming the whole $35,422 plus the $22,000 that she had to write a check for?
Because no, she didn't write a check for that amount. She wrote a check for the 22,000 figure.
Right.
The
But
$35,000
she
figure.
cashed out her account, and she contributed $35,000 from her account to join the pension plan.
It went from her account, but that could have included some funds from the state that contributed also to the investment plan. The $22,000 figure, however, came solely from her funds, and not any part of that came from the state.
But that
So-
22,000 that she had to pay in, I suspect, was more than the sum of the 3% that she would have paid had she been in the pension plan all along?
I don't know that. I don't think there's anything in the record that would say that. The only thing the record included was the actuarial amount that was required for her to come into the pension plan, and that was the $35,000 figure. And because she was short of that, of her own funds, she had to contribute the $22,000 of her own personal funds to come into the pension plan. So,
But do you agree, though, that when the statute talks about contributions, like throughout, on both the investment side and the pension side, there's a consistent reference to that 3%, right?
well, no, not really. The only reference to a 3% or a amount that was actually deducted from her funds on a monthly basis was the statute that's contained only in the investment plan. I think that was the 121.1405, I believe it was. And in fact, that statute talks about the contributions being the monthly sum that was deducted from the member's paycheck.
Right, and
That
121.
statute is not contained in the pension plan where it talks about death benefits. Instead, the statutory provision for the pension plan is broader than that and says, and members' accumulated contributions. The administrative law judge specifically found that he could not consider the statute that was contained in the investment plan because it was not in the pension plan, and he cited a number of cases that specifically hold that where a statute is contained in one part of a chapter and not contained in the second part of the chapter, the legislature knew what they were doing and intended not to include those provisions in the second statute. So, and in fact, the department agreed to that. They never objected to that. In fact, even though they had argued that in front of the administrative law judge, their final judgment, final order does not argue that at all whatsoever. And in fact, they've conceded that they cannot apply that statute to the pension plan.
What about 121.71, which provides uniform rates for both the pension and the retirement? And the
Yeah,
investment plan.
it has nothing to do with the death benefit provision.
Except it
It's
uses the
only
term
talking about
contribution.
how it's funded.
You're saying we cannot look at the functioning of the entire system, which is provided in a variety of statutes beyond just the pension plan?
Wait, you,
If I want to know what a contribution is, and the statute doesn't go to great lengths to define it beyond just assuming that we know what a contribution is, which suggests to me that it is actually a assumed meaning throughout the entire chapter. But let's just say, so 121.71, which establishes specifically how much the contribution is going to be from the employee for both the pension and the investment plans. And it's 3%. It says it right here in subsection 3. You're saying that we can't look at that and say, well, when the statute uses contribution or accumulated contributions, we can't assume that it's referencing that 3%.
I think it shows just the opposite, in fact, because in the provisions dealing with the investment plan, the statute specifically says that the contribution there is the monthly amount. It does not say that in the pension plan, which is a separate portion of the chapter. And the case law is uniform in saying that when there's a different provision in the other provision of the chapter, then the legislature intended not to include what was in, for example, here in the investment plan. And in fact, that's what the department is requesting you to do, is to overrule the findings of the administrative law judge and actually provide a provision that they agreed does not apply to the pension plan and does not apply to the death benefits of the pension plan. Because there's nothing in any of the statutes that they've provided that provides for a death benefit that somehow limits the provisions of 121.0917 to anything other than the members' accumulated contributions, and it certainly doesn't limit it to the amount that was deducted from her paycheck monthly, as was contained in the investment plan. The
And you're
administrative law
getting
judge-
well into your rebuttal time.
What?
You're getting well into your rebuttal time.
Okay, I'm sorry.
May it please the court. I'm Megan Silver, counsel for Appalachia, State of Florida Department of Management Services. I'd like to highlight 3 reasons why the department's final order should be affirmed. First, the statute distinguishes between contributions and additional member payments, and it specifically excludes the use of the term contributions to describe the funds used to transfer from the investment plan to the pension plan. Second, the dictionary definition of the term contributions does not adequately capture its use within Chapter 121. And third, the department's interpretation is consistent with its constitutional obligations, and it furthers rather than obstructs the legislature's express purpose.
So it seems to me that she's not entitled to the $35,422 that was in the investment plan that transferred to the defined contribution plan.
That's correct.
Okay. And she's not entitled to the $22,943 that was the additional amount of funds that had to be contributed to bring the investment plan up to the actuarial value it had to be to cover the benefit, correct?
That's correct.
Okay. And so the department says that she was entitled to the money that represented the 3% employee contribution that she contributed after she became a member of the defined contribution plan.
Of the pension plan, that's
Of the
correct.
pension plan. Okay, so why would not she be entitled to the 3% that she contributed when she was a member of the investment plan? Because it seems like the $35,422, the $22,943 represent the whole amount to make the pension plan whole. So it was actuarially sound. And that money would have consisted of 3% from her all along and the remainder of the required contribution from the state. So why is she not entitled to that 3%?
The reason is because that amount is totaled up as a sum in the statute. The liquidation requires the department to pull all of those, all of the monies together and put it in the pool for the pension plan. During that liquidation, it no longer becomes made up of the member contributions and the employee or the employer contributions and investment returns. It becomes a liquidated amount that is used for a buy-in sum, and that sum.
So she gets no benefit for the 3% she contributed during those years.
That's correct.
Okay.
The statute, I was asking your opposing counsel the same question, but when it references what she has to contribute, and it says a sum representing the employee's actuarial accrued liability, which I think that's what you're talking about. It's a different term than contributions, right?
Yes.
Okay.
So
But it doesn't say she shall transfer the employee's actuarial accrued liability. It says a sum representing that, which suggests to me that there's a formula because she's coming from the outside and someone has to calculate what her liability would have been had she been in the plan all along. Is there anything in the record that shows what that formula is or how that number was arrived at?
Yes, Your Honor. The ALJ actually found that the calculation for the buy-in to the pension plan was established based on the monthly annuity amount, the state multiplier percentage for the employee's position, the years of service, the age, and a lot of factors that the actuary didn't get into in his testimony.
Sure. But did any of those include the 3% that she had already paid in or would have paid in had she been in the pension plan all along?
That is not clear from the record, Your Honor.
I mean,
I don't know that.
I mean, would you, I mean, does the state dispute that number is going to include the 3% that she otherwise would have paid had she been in the pension plan all along?
The state does not dispute that the money that is liquidated contains that 3% that she paid all along, but the calculation doesn't necessarily consider what that 3% is.
I mean, if an employee was in the pension plan all along, that person would also have a actuarial accrued liability? Is that true or false?
I'm not sure. I suppose it could be calculated, but.
But that's not regularly done for everyone, participants in the plan?
Right. It's a calculation that is specific to the need to understand the liability for someone joining the pension plan at a subsequent date after their initial.
So ostensibly, there's a formula somewhere, and an actuary, a very smart person, smarter than us, says, okay, for a state employee with this many years of service and this age in this classification, we can project out what they're likely to earn over the course of their career, and this is the pension liability in 25 years, and so this is how much we need to have right now for that to work.
That's correct. And in fact, they put it into a calculator so that the division can use it, so any of us could calculate it if we have the right figures to put into it. But it does include the consideration of life expectancy and outliers in that life expectancy, and it considers that there are members who will pass away before receiving any benefit at all.
Sure.
And there are members who will greatly exceed their life expectancy, and those factors are considered when figuring out the liability for the plan.
But that money represents a sum that had the person been in the pension plan the entire time would have been 3% of their annual salary plus whatever extra amount the state, and the lion's share the state contributes, whatever extra amount the state would have to contribute to reach that actuarially sound number.
I would imagine that that it includes all of that, but I don't want to overstate the simplicity of the calculator just because
Well, it's proprietary. I mean, it's not in the record, and I don't think it will ever be in any record, the actual algorithm and formula. It's a proprietary mathematical algorithm that the company that has been contracted with the state holds to itself, right?
Yes, that's correct.
So we're not ever
we
going
don't
to see
know.
it in a court document.
Yeah, we
But
don't know the
an
precise
employee that
calculations.
opted for the pension plan the entire time, that amount of money would include 3% of their salary every year.
Yes.
At least after the time the state implemented that.
Yes, and I think I can explain why that amount wouldn't be included. It is due to the liquidation of the funds and the transfer. That considers that they are no longer vested in the investment plan at that time. When those funds are pulled and the money is transferred to the pension plan pool, the member is no longer vested and no longer has a right to those monies. I think that's the difference. The statute.
Well, they no longer have a right to the money that is the investment payout, the big sum of money. But when they're not vested in the, let's say I'm a state employee and I start in the investment plan, and I have to be there a year before I vest. So if I leave it a year and a half, I get to take everything in the account. Correct?
That's correct.
But if I leave it 8 months, I only get my 3% that I've contributed.
Yes.
Okay.
So the statute.
But we know that on the investment side because the statute spells that out a little bit better than on the pension side.
Yes, on the pension side,
Kind of a black box on the.
You're entitled to, in this circumstance, the death benefit under 121.091 sub 7. So.
Yeah, but if I'm a state employee and I am in the pension plan, and I leave after 7 years, I only get the 3% that I've contributed.
If you are a member of the pension plan,
Pension plan.
yeah, and you leave in 7 years, yes, you'll get the 3% from the
But
moment.
if I leave in 8 years, I get the 3%, and then whatever other value is in that account.
Well, you get the benefit that that you'd be entitled to after that many years of service. There's a calculation for the benefits that you get.
But I could get it out and pay the penalty for retiring early, right? and it might take it to zero, or I could leave it in the plan until I got to be 62 and then get some amount of money then.
Yes.
Okay.
Council, and I know it's probably beating a dead horse, but getting back to and I'm not asking whether, I understand why the formula itself is not in the record, but it is conceivable that someone could have asked the question, maybe it was a fact and evidence, that whatever that formula is, we know for sure that it includes one of the variables, one of the things that you plug in, is that 3%, times the number of years of service. Is there anything in the record that would indicate sufficiently that we could split out, and we know for sure that the actuarial accrued, I knew I was going to forget it, so I wrote it down, the actuarial accrued liability, that we know from the evidence that that number, whatever it is, definitively includes that 3% number?
The actuary's testimony may include a reference to that calculation, including the contribution rates for the relevant years. I can't tell you exactly where that would be in the record, but that may have been within his testimony. I know that there were many factors discussed, and I paid particular attention to the ones that were adopted as a finding of fact by the ALJ.
And I won't hold you to it, but let's assume for a moment that there was something that indicates that whatever that formula is includes the 3% she would have contributed had she been in the pension plan all along. Why could we not read that as part of her contributed or accumulated contributions?
Because the accumulated contributions are defined as the member contributions. She was not a member of the pension plan when that 3% was paid, assuming that was an amount within that buy-in amount.
So there's no room for like an equivalency kind of thing? I know.
The statute doesn't provide
Yeah,
for it.
okay.
Well, let me ask you this. Let's take off our lawyer hats for a moment and just put on our plain language hats. And if I sat down with Ms. Hernandez, the daughter, or the mom before she passed, I'd say, well, what did you contribute to the system? She said, well, I put in $13,000 into the investment plan. I contributed that. That was my money, okay? Well, what else? Well, I took $22,943 out of my bank account. I contributed that. And I took $26.54 from the contribution. Though I contributed all that. And using plain language, I would say that, she contributed that. That was her money. She had an entitlement to it. It's her property, right? It was her property interest, no one else's, and she contributed it. Now, we put on our lawyer hats, right? All right. What in the statute bars Hernandez's recovery? What specific language in the statute basically says those contributions? I'm using plain language. I mean, from a plain language approach, those are contributions. What in the statute bars her from getting those back?
In section 121-4501, 4F3, the last sentence contains the words contribution and additional member payments made. The reference to additional member payments made would have to be read as mere surplusage next to the word contributions if all member payments made were contributions. The statute repeatedly differentiates between contributions and other sums, monies, fees, sources of funding. And it acknowledges that there are things that are not contributions that might look like contributions. The context of the statute changes the plain meaning of the term contributions. So while the dictionary may define it that way, and we may speak that way outside of the courtroom, the statute is clear that the contributions that the statute identifies are contributions versus additional member payments made. The provisions that permit the transfer from the investment plan to the pension plan don't refer to the sum or the buy-in requirements as contributions.
Well, and I could see why they didn't, because they're just saying, here's the amount you have to transfer in. I guess it could have been, if they were thinking more favorably towards the employee, saying, you will contribute those. If they use the word contribute, then that would make it pretty clear that truly that is a contribution. But I'm not entirely convinced of what you just said. That it doesn't come across to me as, well, that just precludes an interpretation that these three things I've described to you are actually contributions.
I don't know that it's mentioned in the briefs, but there are a couple of employee contributions, and they are based on that 3%, but they can come out of, from an out-of-pocket payment by a member. That would be purchases and upgrades to service credit. Now, these amounts are called sums at one point, but they're also referred to in the definitions section and in 121.071 as contributions. Because those are called contributions in the statute, they're treated as contributions, and the division would include
So what's
those.
that? Is that like buying federal service time, that kind of thing?
That kind of thing, yes. There
So
are many.
that would be a contribution?
That is
I
a
would get that back?
contribution, and it is called a contribution in the statute.
Okay.
The statute specifically calls those contributions, and the division treats them so. So they would be included in accumulated contributions to the extent that a member is entitled to that.
Do you know what year the legislature put in that 3%?
I think it went into effect in 2011.
Okay, so right about the time, that Ms. Rice started state service, correct?
Yes, so that year
But
the
at all,
statute went
but at
into.
all times, she was subject to the 3%?
Yes, that's correct.
Okay.
So
Were you making, it's just processing now, you're making a distinction between being a member in the investment plan and being a member in the pension plan?
yes,
Is that
I
right?
think that the member status is important because she is no longer a member of the investment plan at the time of liquidation. She's no longer vested. She has no right to those funds once they're pooled with the other pension fund amounts. The pension fund is a shared risk pool for members of the pension plan. So the monies are, while it's based on the members' accrued, actuarial accrued liability, it is not set aside for that member specifically anymore. It is a shared risk pool that is available to the members of the pension plan as a whole.
And the reason I'm asking is, so when you look at 121.021, subsection 26, and it defines accumulated contributions, and it's a member's contributions, you're looking at that, that's a reference to pension plan members and not members in FRS overall?
Members wherever they might be a member. So while that provision would apply to any, so if someone was entitled to accumulated contributions as a member of the investment plan, that would also include that amount. So the accumulated contributions definition applies to the entire statute, but the membership is specific to the individual.
And that's based on what provision in the statute?
Just the word member. The word member implies membership into one of the plans.
Well, couldn't it be a member of the Florida retirement system?
I suppose it could, but the amount is called a sum in the transfer provision. So I feel like the legislature would have deemed that to be a sum that includes the member contributions from the investment plan or something like that. Because that is never, no portion of those monies are called a contribution. I don't think
But
that.
is there somewhere in the statutes that makes it seem, so it references, it's clear that a member, if it's used in Part 2, it's clearly it's a member of that person's a member of the investment plan. And if member is used in Part 1, it's a member of the pension plan. Is there anything in the statutes that makes that clear, that if it's in a different part, it's a specific type of member as opposed to being a member of the
I'm
system?
not sure that there is anything in the statute that makes that clear, but I don't think that is central to the issue of whether or not you have to consider the member contributions from when the member becomes a member of the plan. That's just because the liquidation of the funds is a significant event that removes their vesting rights and removes their right to those funds. That's why it's different. So perhaps there are places where member would refer to multiple things, but here, this employee had no right to those member contributions that were prior to membership in the pension plan because of the liquidation.
The $22,943 came right out of her pocket. It was her money.
Yes.
It sounds like a contribution, but what do you label it?
It would
What
be a
would-
sum or other employee monies. The statute, I mean,
I mean, the
colloquially,
statute
we
doesn't-
might call it a contribution, but the statute doesn't. And the statute is clear that amount isn't.
What statute defines what that is? We know what the amount is, but what label do they put on it?
They call it other employee monies as necessary.
That solves it.
So,
So let's say I'm in the investment plan, and I want to go into the pension plan, and I have more money in the investment plan than the actuarial value that I have to spend to buy into the pension plan. Do I get to keep the difference?
yes, and it stays in the investment plan. The difference will stay in the investment plan, and there actually are statute provisions that address how that money is divvied up depending on what you're entitled to. So there might be a point where you would be entitled to all of it, or just some of it, or none of it.
Okay.
So it seems I'm out of time. So because the department has given full effect to the text of the statute, I ask that you find in favor of the appellee and affirm the department's final order. Thank you.
Your Honor, that's the key. There is, and it's found by the administrative law judge, there is no statute or rule that provides that the money contributed by the employee while she's in the investment plan is not entitled to her benefit when she dies and not being vested. There's nothing that prohibits that.
Counsel, assuming, finish your, I'm sorry,
What?
finish your thought first. Assume instead, I mean, we're living in an age where the market's always going up, more like up until this last month. But imagine a time where instead of her fund and when she was in the investment plan going up, let's say she lost 50% of its value, including a lot of that 3% contribution. And then she transfers it over, she has an actuarial accrued liability that she has to pay. She liquidates the investment plan, the investment fund, and she's way short. And now she has to write a check for that bigger difference. By your position, though, would mean that she would get a windfall, because then she would get that 3% that she lost when on the investment side, she'd get that back on the pension side. No?
You mean when she transfers into the pension plan?
Well, but she's transferring, but she's writing a check. In every event, she's writing a check to get the buy-in. But if she transfers over, she's writing a bigger check, because when she liquidated the investment plan, she's down 50%, and so she's lost some of that 3% that she had contributed. And then she'd be asking for it, or her state would be asking for it back on the pension plan, even though she lost it when she was in the investment side.
I don't.
Isn't that the
Let me help
I don't
on
believe that's
your hypo.
Okay.
provided
Okay,
for.
let's say she joined the investment plan and invested in the Enron fund, and it went to zero. But then she wanted to get back in the pension plan, right? And the department looked at it and said, okay, to get back in the pension plan, it would cost you about $58,000 and change, right? That's what these two numbers add up to. Under your theory, she would get the benefit of all that money she lost. She would
No.
get that back.
She's only getting the benefit of the money she actually contributes. It's not money that she lost. It's the money
No,
that
but if
she
her-
has
but
to
if her-
pay of her personal
Okay,
funds.
let me finish. But if her investment plan account had gone to zero, under your theory, she would have had to contribute some $58,000 to get into the pension plan.
Yes.
And that would be her contribution.
Yes,
Is
it
that
would
your
be.
argument?
Yes, because
Okay.
she's personally contributing. What they're arguing flies in the face of the testimony of their own witnesses. The department actually calculated that she contributed $13,000 some dollars while she was in the investment plan. That's the money she contributed, wasn't the state's money. So that's all we're asking, that she gets back her money. As far as this sum being liquidated, their employees testified that the funds that she contributed, the $22,000.
Okay, you're over time right now, so I need you to sum up in the next 30 seconds or so.
Okay, I'll their testimony, though, if you read the record, they testified that it's treated the same as any pension plan funds, into the same fund, and there's no difference in it. So we'd ask that you basically reject their final order and affirm the order that was entered by the administrative law judge, because they haven't met their burden to show that their final order was as or greater than, more reasonable than those findings by the administrative law judge.
Thank you, Mr. Kearns. Thank you, Ms. Silver, and we are adjourned.
All rise.